Okay, today is October 26th, and we're going to be talking about the steps in civil litigation, BA 230, fall 2021. All right, this is page 26, I think. Okay, so today we are going to talk about, last time we talked about the courts and dispute resolution. And today we're going to talk about a civil lawsuit, basically what the major steps are in the process of a civil lawsuit, litigation or a lawsuit. So going through the court system in a civil case. So this is different than criminal. Criminal has a different procedure in the way they follow things. Some of the things are the same, some are different. We're not really going to talk about a criminal process. We're going to focus on civil. And partly because it's a business law class, so in business it's really common nowadays, especially larger businesses, that at some point there will be some sort of a civil lawsuit involvement. Your company might get sued, you may have an employee that did something wrong, which led to an injury or a breach of contract or some other type of civil dispute, and therefore the business has to respond to it. So you, maybe as the owner of the business, you got sued, and so you need to respond to the civil lawsuit, or you might be an employee working for a company, and you are going to have to work with the attorneys that are defending the company. Maybe you work in the human resources department, or you work as a mechanic, like I say, I used to do a lot of trucking, and so our mechanics all the time would get subpoenaed to come testify at a civil case involving maintenance of a semi-truck or that kind of thing. Or it might be the payroll department, or operations department, or financial department, whatever the case may be. You might be involved, not that you got sued, but because you're an employee, you would be involved in the preparation and maybe going to depositions and trial and the discovery process and that kind of thing. So basically the idea is I want you to have a basic understanding of how a civil lawsuit works and how it proceeds through the court and some of the important steps along the way. And I've put up here the main ones I want you to know about as I'll work our way through. The different various pleadings and the discovery process and that kind of thing. Okay, so just to give it some background, we were talking about the fact pattern that was in the textbook that we talked about last time. And just to remind you, that involved Anthony Caruso, who drowned, and his partner Elizabeth Smiles filed a claim with the life insurance company, and they refused to pay $2 million life insurance policy. And so assuming we tried to do negotiation and that didn't work, we tried to resolve the case without having to go to court, but ultimately we were unable to do that, so that leaves us with going through the court system, filing a lawsuit, and proceeding through litigation. So let's take a look at the major steps. So as I talked about last time, first thing is we're going to try to negotiate the case. Maybe we'll do mediation. If that doesn't work, maybe an arbitration. Try to settle the case if we can. But if we're not able to, that leads us to the first step. So the first step in a civil lawsuit will be to file the complaint right here. File. Okay, file a complaint at the courthouse by the plaintiff's attorney. So a complaint is a document that is prepared by the lawyer that represents the injured party or the party that is filing a lawsuit, the plaintiff. So in this case it would be Elizabeth Smiles. So if I was her attorney, I would then be putting together the complaint, which is a first type of what we call a pleading. And that is the document that I will file with the judge, with the court, and that will initiate the lawsuit. So let's take a look at what a complaint looks like, just to give you some idea. So if you look over on page 35, this is from the textbook outlining this dispute with the life insurance company. Now I will tell you right now, this is a highly abbreviated version of what a real complaint would look like, but it gives you the basic ideas. So a complaint is the first type of what we call a pleading. We'll get to those more in a minute, but essentially pleadings are the documents that the lawyers file with the court to sort of give an outline to the judge. So the judge has a basic outline of what the whole case is about, the basic facts, the underlying theoretical legal basis for the case, like a breach of contract or an automobile accident, or whatever the case factual situation is. And then also a complaint, the job of a complaint is to outline what you're asking for from the court, what remedy you would like as an outcome. Now, typically that's going to be a monetary, a dollar amount, but it may be some other kind of remedy, like a court order or something like that, and we'll get to that more in a minute. So the basic idea of a complaint is just in a real abbreviated kind of an outline format. You're going to go through and tell the court a little bit about what the case is all about. So first of all, as a pleading, there are rules of the court on how we have to write these, and you have to be very precise and write them according to the rules of civil procedure, it's called. Same thing in criminal court. There are rules on how criminal court paperwork is submitted to the court. So first of all, if you see over here on the side, all pleadings, all the documents that you submit to the court must have what's called pleading paper. That is numbered lines on the side. And that's the term for it. That is called pleading paper, which is a macro in Microsoft Word. And the reason for that is that way when we're in actual court, we can refer to the page and the line number, and everybody literally can be on the same page, right? It's kind of a joke, but it's true. So if I'm in court, I could say, please refer to page 34 and go to line 18, and that way we can all kind of follow along. So whenever you see that type of paperwork there, that's called pleading paper, and that's the purpose of it. The second thing is at the top here, we see this is called the case caption. That has to be on the top of every pleading type document that is submitted to the court. And that's going to tell us the name of the court. So this is the State of Oregon Circuit Court for Multnomah County, up in Portland. And then we have the parties to the complaint. In this case, it's Elizabeth Smiles, who is the plaintiff. So she is the one that is filing the lawsuit. And then we have Coastal Insurance Company, which is the life insurance company that did not pay. They are the defendant. Now remember last time we talked about that, or a couple classes ago, plaintiff is the party that files the lawsuit. The defendant is the party that is being sued. Then over here, we're asking for a jury trial, and then we have the name of the pleading. So this is a case caption, and you'll see that again here as we work our way through. The next part of a complaint is where we're going to get into the factual background. And again, these are not all of the facts of the case, but the job of the plaintiff's attorney when they write the complaint is to provide enough information in the complaint in a summary, kind of an outline format, that will tell the judge a couple things. Number one, is it the correct type of court for jurisdiction purposes? Number two, what are the basic facts of the case so the judge can have a general idea of what the case is all about, what the factual scenario that supports the lawsuit, what is alleged to have occurred, what they're complaining about, what they're alleging that the defendant did wrong, what laws may have been violated. So the component of the complaint that have the numbered paragraphs right here is where you'll put the factual information. So let's just take a look at that real quick. So plaintiff Elizabeth Smiles states that, number one, she is a citizen of Multnomah County, Oregon. Number two, defendant Coastal Insurance is incorporated under the laws of the state of Georgia and has its usual place of business there in Savannah, Georgia. Number three, on or about July 5th, 2012, Plaintiff Smiles, Defendant Coastal Insurance, and Anthony Caruso entered into a contract, a copy of which is annexed as Exhibit A. Contract was signed by all parties or their agents in Multnomah County, Oregon. All right, so I'm just going to stop right there, paragraphs 1, 2, and 3. So why are those first 3 paragraphs important? Why does it matter where she lives? Why does it matter where the insurance company is incorporated? Why does it matter where the contract was signed? Why even put that in there? Who cares? Yeah. Exactly, jurisdiction. Right out of the chute, we're telling the judge, or showing the judge, here is why the court has authority over this case. Here is the basic jurisdictional, factual information that supports the lawsuit being filed in the Multnomah County Court. So personal jurisdiction, she lives in Multnomah County. Personal jurisdiction for the insurance company, they're doing business in Oregon by selling insurance, and also that's where the contract was signed. So that's providing the jurisdictional background. If you don't provide that information in the complaint, the attorney for the other side, for the insurance company, the defendant's attorney or defense counsel, will file a motion to dismiss for lack of jurisdiction. Now, you might have the opportunity to change or amend your complaint, but that's up to the judge. Otherwise, the judge may just dismiss it. You might be able to refile it, or you might not be able to, depending on how the judge does that. So that's the first 3 paragraphs of the complaint. What are the factual background that supports the jurisdiction? Next, we get into what is alleged to have occurred that led to the lawsuit. So paragraph 4, right here. The contract obligates Coastal to pay Smiles the sum of $2 million if Anthony Caruso should die accidentally. Number 5, on or about September 20th, 2012, Anthony Caruso accidentally drowned and died while swimming. Number 6, Coastal has refused to pay any sum pursuant to the contract. And finally, number 7, Coastal has knowingly, willingly, and unreasonably refused to honor its obligations under the contract. So essentially what you're telling the judge is that the insurance company had a contract, $2 million is the monetary value of the insurance policy, and the insurance company declined to pay. So the first 7 paragraphs there, those are the paragraphs that basically set forth the facts, what happened, what led to the complaint being filed with the court, what is alleged to have occurred that was wrongful. And then the second part of a complaint, down here below, this is where you will tell the judge what outcome you want from the court. Wherefore, Plaintiff Elizabeth Smiles demands judgment against the defendant Coastal for all money due under the contracts, that would be $2 million, semicolon, demands triple damages for Coastal's knowing, willing, and unreasonable refusal to honor their obligations, so that would be an additional triple damages, so additional $6 million, and all costs and attorney fees along with interest. So essentially you're asking for $8 million, right? $2 million for breach of contract, triple damages for basically bad faith by the insurance company, which would be a form of a punitive damage because they unreasonably refused to pay on the contract, and then finally attorney fees and costs. So that's the paragraph where we're telling the judge what we want. So to kind of break it down real simple, the first part of the complaint, what happened, what is the background factually. The second part of the complaint, what do you want? What happened and what do you want as a result? Okay? Those are kind of the 2 basic purposes. So the complaint will then be filed with the court. Nowadays it's done through e-file, so we basically upload it in a PDF format, we scan it, and then we e-file it on the internet, pay the filing fee with a credit card, and that will start the lawsuit. So once that occurs, we move on to the next step. But before we do that, I want to talk about the idea of the term pleadings in a little bit more detail. So page 28. Whoops. So you can see here, this is a list of the various pleadings that may be filed. These are not always filed. Some of these are only in certain kinds of cases. But essentially I want you to be able to list out up to 4 of these for a fill-in-the-blank question. And on top of that, I want you to know which party to the lawsuit, either the plaintiff or the defendant, which side in the lawsuit filed that type of pleading. And if there's an easy way to remember it, which I'll show you in a moment. So first of all, we have the complaint, which we've talked about. That's the first type of a pleading. So what are pleadings to begin with? Pleadings are specialized documents. A plead, you're asking for something, please give me, you're making a plea to the court, and both sides in a lawsuit will file them. The complaint, of course, is filed by the plaintiff. That will start the lawsuit. Now, pleadings have 2 basic purposes. At the bottom down here, the first is setting forth allegations or statements of factual issues. Issues of fact, issues of law, what happened, who, what, where, why, and when. That's what we just looked at in the complaint. So what are the facts that formed the basis for the lawsuit? Now, you're not going to list every little detail. However, you have to list sufficient factual information to set forth jurisdiction, and also to give the court and the defendant, the party that you're suing, sufficient information so they know, in a basic generalized way, what the case is all about, what they're accused of doing, if you're suing somebody, what you're alleging they did wrong, that forms the basis for the lawsuit, to give them adequate notice so they know what the lawsuit's all about. So if I just filed a lawsuit and the lawsuit said the insurance company did something wrong, but I don't say what it is, I don't say when it happened or where it occurred, it's not enough information. So a judge is going to throw that complaint out because it's not specific enough. Now, you don't go into every single detail. I mean, it would be hundreds of pages long. Now, sometimes complaints are very, very long. I mean, I've seen complaints that are close to 100 pages. But for the most part, they're usually about, in a simple case, this is a fairly simple case, usually about 4 to 5 pages long. Not super detailed, but enough to where you kind of know an outline of the case. So that's the first purpose of the pleadings, to outline factually what you believe happened, what you intend to prove in court to substantiate your case. The second purpose of a pleading is to request a remedy. The word remedy is a term that refers to what you are asking as a result if you win the case. What are you wanting to remedy the problem as best as can be done? Now, in our case, we're asking for money. We're asking for $8 million plus attorney fees and costs. So there are 2 basic categories of remedies. One category is called a remedy at law, or a legal remedy. And that is when you're asking for a monetary award. Lost profits, out-of-pocket expenses, monetary damages for breach of contract, medical expenses, lost wages, some kind of monetary amount as a remedy. You want to be compensated for the money that you lost, and you want to be compensated if it's an injury case, for example, for your pain and suffering. So if you're asking for money, that is called a remedy at law, or a legal remedy. That is money. The other type of remedy is called an equitable remedy. Right here, equitable. That's typically a court order of some type, and it's not money. You're not asking for money. You're asking for a judge to issue an order of some type. So for example, perhaps it was a case involving environmental law, like the Endangered Species Act. And so maybe a conservation group filed a lawsuit and they're asking for a judge to order a logging company not to cut down trees in a particular area because it will destroy habitat for an endangered species. Well, in that case, you're not asking for money. You're asking for what's called an injunction. That is a court order that the judge would issue prohibiting the cutting of trees in that area. So it's not monetary, it's a court order. Or it might be maybe somebody's playing your music, if you're a musician, and they're not compensating you. So they're violating your rights as a musician to your copyright and trademark on your music. And so you could ask for an order prohibiting somebody from playing your music. It's called a cease and desist order, to prohibit them from playing your music or using your logo or something like that. Or it might be other types of court orders, like a restraining order if somebody is stalking somebody, or a no contact order, those kind of things. So there are two types of remedies. A remedy at law is where you're asking for money, and an equitable remedy, or equity, is a court order. Now, I have another page on those, which I don't get into that much detail anymore, page 31. I used to ask this as a fill-in-the-blank question, but it's way too detailed, so I had X's through it. All I want you to know is this. There are two basic types of remedies. One is a remedy at law, where you're asking for money, and that may be for lost profit, or out-of-pocket costs, or unjust enrichment if somebody's making money off of your logo or your music. They can pay you back for the profit that they made. The other is an equitable remedy that is not involving money. So that'd be like an injunction, a court order to prohibit logging. Rescission would be terminating a contract. Reformation would be an order by the judge redoing the terms of a contract, reforming the contract. So you don't need to know those, I cross them all out. Oh, specific performance. That's where a judge orders somebody to complete a contract. So maybe it's a real estate transaction. We have a purchase contract with each other, and you sign the contract, I sign it, we agree, and then you decide you're not going to sell the property. So I can sue and have a judge order you to sell your house because we have a contract. That's called specific performance. Now, I'm not going to test you on those details. I just want you to know real simple. A remedy at law or a legal remedy is money. An equitable remedy is a non-monetary remedy. Now, just to give you some background on where that came from, back in Old England, they had two types of courts. They had courts of equity, and they had courts of law, court of law. And when you filed a lawsuit, you had to choose which type of remedy you wanted. So if I wanted a court order, I would file in a court of equity. If I wanted money, I would file in a court of law. You could not ask for both. Now, in the United States, we have merged, and so our courts, for the most part, are both courts of law and courts of equity. And what I'm leading up to in the real world is you can ask for both a monetary remedy, a legal remedy, and also an equitable remedy in the same case. So again, if you were playing my music without paying me, I could file a lawsuit and I could ask for an injunction to prohibit you from further playing my music without permission. And I could also ask for monetary damages for the lost profits I made for you not paying me for playing my music or showing my movie or whatever. So I could ask for both. But the key is this. I have to detail in my complaint what remedies I'm wanting. I have to tell the judge in detail exactly what outcome I'm requesting. And that's both to tell the judge what I want, but also to let the other side know what I'm asking for so they can defend themselves. The old saying, if you don't ask for it, you don't get it. That's very true. And that's exactly what one of the purposes of the pleading is, to tell the judge, hey, this is what I want as an outcome. Now, you may not get that, maybe a smaller dollar amount or something else, but if you don't ask for it, you cannot get it. So it's, oh, I forgot to ask for an injunction, judge. Too bad. You might be able to amend your pleading, but depending on how far along the case you are, you may not be able to. So that's one of the purposes of the complaint, is to specify which type of remedy or multiple types of remedies that you're asking for. All right. So we'll come back to pleadings in a minute. And just so you know, over here on the side, that's a PL, that's for plaintiff, because the plaintiff files the complaint. And then we have D for defendant, and then down at the bottom, PL for plaintiff. All right. So back to this page here. And I apologize for jumping around so much. So we have now filed the complaint with the court. The lawsuit has now been initiated. The next step is the lawsuit has to be served along with what's called a summons on the defendant. You may have seen that on TV. You've been served, right? They have the process server that goes out, or a sheriff's deputy. The police officer will go out and serve papers to somebody and knock on their house in the middle of the night and here are the papers. So you have to serve a summons and a complaint upon the defendant. That will start the time running once you serve the defendant with the summons and the complaint. So let me show you what a summons looks like. Page 33. Okay, this is a summons from a case I did years ago. So basically, a summons is like an invitation to a party, kind of. It's saying, a lawsuit has been filed against you, and you have an obligation to appear in the court or you're automatically going to lose. So again, we have the case caption at the top. And then if you look right here, we have a paragraph that says, you are hereby required to appear and defend the complaint filed against you in the above entitled action within 30 days from the date of service of this summons upon you. In a case of your failure to do so for want thereof, the plaintiff will apply to the court for the relief demanded in the complaint. So basically, you have 30 days from the date you were served to do something, or you will lose automatically. Now, 30 days is the standard for Oregon courts. In small claims court, it's only 15 days, however. In federal court, it's usually only 20 days. So the number of days will depend on what court you're in. So if you're ever served with a summons and a complaint, the first thing I want you to do is write down on the top of the page the date that you were served. That's the first thing you should do. Freak out, oh, I just got sued. Write down the date and time, or the date. Sometimes I'll write down the time too. The time is not as critical. But that's the date that 30 days begins to run. Now, the reason why that's so important, you write that down, is you may forget. I mean, you're emotional, you're stressed, you just got served with a lawsuit, right? You're freaking out. So write that down, because that's the first question I'm going to ask if you come in to see me to defend you in the lawsuit. When were you served with these papers? I've literally had people show up at my office and they pull this crinkly old crumpled up piece of paper out of their pocket. Oh, I got this, somebody showed up at my house and handed this to me. Can you help me with this? I'm like, well, when was this? Oh, I don't know, somewhere around spring break, back in March. I'm like, okay, well, I have nothing I can do to help you now. You had 30 days. Literally, I've had people show up 2 months after the fact. Or worse yet, the day before it's due. I usually decline to do the case because I don't work that fast. You make mistakes. So That's very important. You write down the date and time that you were, or the date that you were served, that way we can remember. So what do you have to do? All right, I apologize, this didn't copy super well, but, all right. You must appear in the case, or the other side will win automatically. To appear, you must file with the court a legal paper called a motion or an answer. Motion or an answer. Boy, that's really good. Motion or answer. So we serve the complaint along with the summons on the defendant. They will then contact typically their insurance company if it's an automobile accident, and then the insurance company will hire a lawyer, or if it's some other type of case, the defendant will have to engage an attorney to represent them and to file a motion or an answer with the court to respond to the complaint. And if you don't do that within 30 days, you will automatically lose. If you don't file within 30 days, that's called a default. You lose by default. Just like in sports, if you don't show up for the game, you forfeit the game. Same thing in court. If you don't file, you will lose by default, and whatever is requested as a remedy in the complaint, the court will grant, for the most part, in a default. So, a motion or an answer. Back here to page 26. So we're on step 4 now, a motion to dismiss or an answer. So the first thing, if I'm the attorney for the insurance company, I'm going to review the complaint. I'll do a little bit of investigation of my own to determine what happened, what evidence there is to support the complaint. And then if it's supported by the facts, I will file a motion to dismiss. Now, a motion to dismiss is basically where you're asking a judge to throw out the case right at the beginning. And the reason for that, there are basically 2 major reasons. Number 1, motion to dismiss. No jurisdiction. Sorry, my handwriting's bad. Okay? So if it's the wrong court, then I will file a motion to dismiss, and I'm asking a judge to throw out the case because it's the wrong court. The court lacks jurisdiction. Or if there's insufficient information in the complaint to determine that, I can file the motion to dismiss, and then the judge will tell the plaintiff to either provide additional information about jurisdiction, or depending on the judge, they may just dismiss it, and then the plaintiff will have to refile the whole thing over again with more information. So that's one basis. So in our case, it was filed in Multnomah County Circuit Court. We've already figured out that she lived there, the insurance company does business there, the contract was signed there by everybody in Multnomah County, so clearly there's jurisdiction. So I'm not going to file a motion to dismiss for lack of jurisdiction because the complaint shows that clearly there is, and that's usually the case. I mean, a lawyer typically is not going to file in the wrong court just because, 1, it's a waste of time and money, plus it makes the judge mad. You don't want to make judges mad. It's a bad thing. So the second reason the second reason for a motion to dismiss is that the case is too old. It wasn't filed within a time limit that is established by law. That's called a Statute of Limitations. You may have heard that term before. That's a fancy way of saying a law that establishes a time limit to file a lawsuit after an event occurs. So a statute of limitations will depend on where you're at in the type of case. States vary from state to state about statutes of limitations. But just to give you an example, here in Oregon, for an automobile accident, if you get into a car crash, there's a 2-year statute of limitation. After 2 years, it's too old. For a breach of contract case, it's usually 6 years, but it may be up to 10, depending on the type of case. If there's fraud involved or forgeries or something, it could be extended. Some other types of cases are only 1 year statute of limitations. The same thing in criminal law. Crimes have a certain period of time. Misdemeanors are usually 2 years, felony usually 3 years. In murder, there's no statute, indefinite. So one of the things you got to look at is what is the statute of limitation for that particular type of case. All right, so in Oregon, a breach of contract case must be filed within 6 years of the breach of contract. So, is there grounds for a motion to dismiss in our case? We'll look at the complaint again. When did the breach of contract occur? We don't know exactly, but you can ballpark it. $2018? Is that what yours? Yeah. My book's out of date. It says 2012. All right, so 2018 plus 6 years. So that would be what, 2024?
Yeah.
All right, so is it timely filed?
Yes.
Yeah, it's within 6 years. So within the 6-year statute, the case was timely filed within 6 years. So therefore, no motion to dismiss for lack of jurisdiction. I'll just show you something. This is the old one, I updated it. This is from the previous version of the textbook, 2012. Now, if it was 2012, then we'd have a problem, right? Because that would be 2018. So in that case, the case would be too old. But in our situation, it's 2018, and that's within the 6-year statute of limitations. So therefore, no motion to dismiss will be filed because the court does have jurisdiction and the case is within the 6-year time limit. So that leaves the defense attorney with filing what's called an answer. An answer. Right here. So that's the second major step in a civil lawsuit that I want you to know about. C, over here, complaint. A, answer. In most lawsuits, those are the two pleadings that will be filed. Most of the time, there will not be a motion to dismiss, and the reason why is, again, the plaintiff's attorney typically is not going to file a lawsuit that has a problem with jurisdiction or is too old just because it's a waste of time and money. So the first step is a complaint, the second step is an answer. An answer is the second type of pleading. Right here. And that is what's filed in response to the complaint. The defendant, through their attorney, will file the answer. So let's look at an answer. All right, page 36. So, again, case caption. This actually should have numbers on the side, but it didn't photocopy, right? Case caption, answered. Defendant Coastal Insurance Company answers the complaint as follows. Admit, 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 deny, admit, deny. How long did that take me to read? Like literally, if I was dictating this, I dictate most of my work, and then it gets typed up. So I would dictate it, and I would, if I'm the attorney writing this up, I would say, okay, this is in a coastal insurance file. Paragraphs 1, 2, 3, and 4, we're going to admit. Paragraph 5, we're going to deny. Paragraph 6, admit. And then paragraph 7, deny. Put it on standard pleading paper, Clackamas or Multnomah County Circuit Court, and then it would get typed up. So that maybe took me about 20 seconds to dictate. And then I bill like 5 hours at $300 an hour. Why? Because I'm a lying, cheating lawyer? No. Because it takes a lot longer than just dictating for 20 seconds to be able to know whether to admit or deny. Let me show you what I'm talking about. When you file an answer, you have to admit or deny the statements that are made in the numbered paragraphs of the complaint. I just realized your guys doesn't have that cut off, did it? The pleading paper. So admit, 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 deny, admit, deny. So when you admit something, it becomes not proven, but agreed upon. So when we admit that Elizabeth Smiles is a citizen of Multnomah County, that now becomes proven, agreed, stipulated, whatever you want to call it. It's no longer a fact that is in dispute. So the parties have now agreed essentially on that fact. No longer needs to be proven in court, it's agreed. Number 2, they're agreeing that the insurance company is from Georgia. Number 3, they're agreeing the date, July 5th, 2018 was when the contract was signed. And they're agreeing that the copy of the contract that's attached as Exhibit A is in fact a true and correct copy. Now think about that for a minute. It took me 20 seconds to dictate admit, 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 deny, admit, deny. However, in order for me to admit that the contract that's attached as Exhibit A is in fact correct, I've got to read that contract, right? You ever read an insurance contract? If you can't sleep at night, just pull an insurance contract out, put you to sleep instantly. They're very, very detailed, so I would have to go through as a lawyer, read it to make sure, double check it against my client's copy, make sure they haven't left anything out or added anything to it. I would have to check with the insurance company, whoever is in charge at the insurance company, to make sure, hey, is this really the contract that they've attached to the complaint? So that alone is going to take me a couple hours just to go through all that. And so it's very important. What if they attached a phony copy of the contract and I just admitted to it? I got a major problem now. So that's what I mean. There's background that needs to be done. Number 4, the contract obligates Coastal to pay Smiles a sum of $2 million. They admitted to that. So they basically have admitted if he died accidentally, they owe the money, right? They've admitted to that. But they denied number 5. On or about September 20th, 2018, Anthony Caruso accidentally drowned and died while swimming. They denied that, which means everything in that sentence is now in dispute. That would include the date of September 20th. That would include whether or not he drowned and was dead. But most importantly is that word right there, accidentally. This whole lawsuit comes down to that word, accidentally. This whole case, an $8 million lawsuit, comes down to one word, accidental. If Anthony Caruso drowned accidentally, they owe the money. If he committed suicide, which is intentional, not accidental, then they don't owe the money. That one word is the whole lawsuit right there, the whole thing. They admitted number 6, that they refused to pay any money, and they denied number 7, that they did so unreasonably. So now the judge, by taking the answer in the complaint, can go through and match up the admit and deny and have a pretty good idea about what the position of both sides in the lawsuit are going to be. In just a real quick, brief type of a format. That's the basic idea. Now, in the real world, there's a middle ground, admit or deny. In the real world, if you don't have enough information at that time to be able to specify, you can also say, the defendant is without sufficient information to admit or deny, therefore the defendant denies at this time. And that does happen. The thing is, once you admit it, you can't go backwards. Once you've admitted it, it becomes proven. And so you got to be very careful about what you admit, because later, if you admit something and you later want to deny it, you may not be able to. You may be stuck. It's kind of like a ratchet. It only goes one way. All right, so back to our pleadings. So the first type of pleading is a complaint. The second is the answer, which the defendant will file in response to the complaint. Now, sometimes you'll have other pleadings that will come into play. So, what if the defendant has a claim back against the plaintiff? So in other words, the plaintiff sued the defendant and the defendant wants to sue them back. It's called a counterclaim. A counterclaim. So for example, let's say that you ran me over with your car, I was in the crosswalk, and you didn't notice me, and you ran over me and you broke my leg. So I sue you for breaking my leg, for negligence. So after I get out of the hospital, I come over to your house, I ring the doorbell, still on crutches and everything. You answer the door, and I punch you in the face. So that's assault and battery, which is also a crime. So you then file a counterclaim against me when I sue you for breaking my leg for punching you in the face. So you would file an answer, and in the answer you would maybe deny your responsibility for the car accident, and then you would file a counterclaim back against me for assault and battery. So it's basically a lawsuit back against the plaintiff. Now, usually it's not kind of that extreme. Usually it's more of a situation where the defendant wants to have their attorney fees paid if they win the case. So maybe they're saying that there's no basis for the lawsuit, so they will counterclaim for attorney fees and costs for a frivolous lawsuit or abusive process or something like that. So it's real simple. A counterclaim is when the defendant files back against the plaintiff. So when that happens, that has to be served on the plaintiff, and then the plaintiff must file a reply to the counterclaim. Within 30 days. So the complaint and the reply are both filed by the plaintiff. Now, do you have a counterclaim in every single case? No. I would say probably 60 to 70% of the time there will be no counterclaim. But the other 30 to 40% of the time there will be a counterclaim. So it just depends on the type of case. Now there's another type of pleading, and this is called a cross-claim. And this is where there is a third party that needs to be brought into the lawsuit because they share some responsibility or full responsibility for what happened. And they were not named in the original complaint. So the defendant wants to bring them in. So let me give you an example of what I'm talking about. Okay, so let's say this is a stoplight, right? So here I am in my car. I am stopped, waiting for the light to turn green. Minding my own business, just sitting there. You come up behind me in your car, and you stop behind me, right there. So along comes, it's a big dump truck, going 50 miles an hour, doesn't notice you, runs into you, going 50 miles an hour, and then you hit me. You ricochet, you're carrying. So I'm sitting minding my own business. Dump truck driver runs into you. Dump truck driver then causes you to run into me. You rear end me, and as a result, I'm injured. So I sue you for rear-ending me. but I don't sue the dump truck driver. So in the complaint, I set forth the information that I was stopped at a red light, that you were behind me, and then you ran into me, causing me injury. So you would file an answer, and in your answer you would put in the factual part that you were stopped legally and lawfully behind me, and you were hit by the dump truck driver through no fault of your own. You then ricocheted into me, which caused the injury, and therefore the dump truck driver is the one that's truly at fault, and therefore the dump truck driver should be brought in through a cross-claim as a third-party defendant, because they're the ones truly at fault. So you would file that, and then that would have to be filed and served upon me as the plaintiff, and then it would also have to be served upon the dump truck driver along with the summons. And then the dump truck driver would have to file an answer responding to the defendant's cross-claim. It gets kind of confusing, but the idea is basically you need to bring a third party into the case because they share some or all of the responsibility that led to the event. These are pretty common in automobile accidents, also in surgery. Maybe you have a medical malpractice claim, and the claim has to do with whether or not maybe somebody did something wrong during surgery and you had multiple surgeons involved, and we're not really sure which surgeon it was that didn't maybe sew the wound up properly at closing. Maybe they left a sponge, they sewed a sponge inside somebody. That happens fairly commonly. So the idea is we don't know which surgeon was involved, so we sue one of them, and then that surgeon will cross-claim against the others. Something like that, okay? All right. So, how can you remember who files which type of pleading? If the pleading, the name, has PL in it, it's filed by the plaintiff. Complaint, PL, plaintiff, PL. Reply has a PL, plaintiff has PL. So those are the two types of pleadings that are filed by the plaintiff. The other three that don't have a PL in the name, answer, counterclaim, cross-claim, are filed by the defendant. That's a real easy way for you to remember that. So on the midterm, list 4 is a fill in the blank question. So what are 4 types of pleadings? And then anything on this page. And then the other type of question would be more of a multiple choice or true false. Which side files which type of pleading? So I may say, okay, true or false, the plaintiff files the cross-claim. And the answer would be false. Or true or false, the plaintiff files a reply. The answer is true. So if it's got PL, that is the plaintiff. All right. And then I also want you to know the 2 basic purposes of pleadings, and that is statements of fact and telling the judge what remedy you want as an outcome of the lawsuit. So once all the pleadings are done, I shouldn't say it that way. The next step is discovery, right here. Discovery. So the term discovery refers to the process of a civil lawsuit where the lawyers for both sides engage in investigation and learning about what evidence there is, what witnesses there are, what documents, photographs, videotapes, police reports, tax returns, all that kind of stuff, whatever's relevant to the case. This also allows the lawyers to get information from the other side in the lawsuit through the discovery process. And we have various tools and methods that we can utilize as lawyers to be able to engage in this investigation and to ask for documents from the other side in a lawsuit, or to obtain documents or other information from outside of the lawsuit, like from a bank or for bank records, or a hospital for medical records. that are not part of the lawsuit, but we could subpoena those records to obtain them to help investigate our case and present evidence when we go to trial. So this is called the discovery process. So page 29. All right. So again, potential fill-in-the-blank question, 90% list 4 methods of discovery.